A judge in Washington state just upheld a law that critics say allows schools to keep major information about children hidden from parents. Not criminals, not predators, parents. And the argument from Olympia is basically this: the government knows better than mom and dad. Think about how insane that is for a second. You can't buy cold medicine without ID. You can't take a field trip without a permission slip. But somehow, when it comes to identity changes, pronoun changes, and major psychological issues inside public schools, the state's position is increasingly, parents don't necessarily need to know. Tonight we're breaking down the HB 1296 court ruling, the federal collision course that's forming around parental rights, and why this fight is far from over in Washington state. From Seattle to Los Angeles, this is Left Coast News. No apologies, just the truth. Welcome back to Left Coast News. Tonight's story isn't really about politics first, it's about authority. Who raises children, parents or state institutions? Because Washington state just drew a very clear line in the sand. What just happened in court? On May 15th, Thurston County Superior Court Judge John Skinder rejected a lawsuit challenging House Bill 1296. That lawsuit was brought by parents and school board members from places like Kennewick, Linden, Deer Park, Darrington, Woodland, Olympia, and Tumwater. Their argument was straightforward. The rewritten law weakens parental rights and creates a framework where schools can withhold major information from families. The state argued the opposite. The Attorney General's office basically said critics are exaggerating and turning policy disagreements into constitutional claims. But here's the critical thing people need to understand. This isn't happening in a vacuum. HB 1296 rewrote Initiative 2081, the Parental Rights Initiative passed the year before. That original initiative guaranteed parents' rights to review instructional materials, access student records, opt kids out of certain sensitive assignments, and receive records within 10 days. The rewrite extended some timelines out to 45 days and changed how schools handle sensitive student information. And that's where the explosion started. Because once government starts slowing, filtering, or restricting parental access to information about their own children, people immediately ask the obvious question: what exactly are they trying to keep hidden? Funny how trust in institutions collapse after years of institutions repeatedly lying to the public. Weird mystery there. Humanity remains undefeated at creating its own credibility crisis. The real issue isn't just pronouns. The media keeps framing this as purely a transgender debate. That's only part of it. The deeper issue is whether public schools can act as independent decision makers over children while bypassing parents. Under current OSPI and WSSDA guidance in Washington, schools are directed to use requested names and pronouns. Schools are advised not to automatically notify parents, and staff are instructed to consult with students before discussing gender identity issues with families. Critics call that state-sanctioned secrecy. Supporters call it student protection. Now here's where this gets legally dangerous for Washington state. The U.S. Supreme Court and federal agencies have shifted dramatically on this issue over the last several months. According to recent federal actions and rulings, parents possess constitutional rights concerning upbringing and medical decision-making. Schools cannot maintain hidden educational records systems. And blanket non-disclosure policies are increasingly being challenged under FERPA and constitutional due process standards. That creates a direct collision between Washington state policy and emerging federal interpretation. And schools are stuck right in the middle. The federal collision course. This is the part Olympia may be underestimating. A major legal turning point came with the Supreme Court's intervention in Mirabelli versus Bonta, involving California policies similar to Washington's guidance structure. The court signaled that parents have constitutional protections regarding major identity and mental health-related developments involving their children. At the same time, the U.S. Department of Education has increasingly treated gender support plans and related documentation as education records under FERPA. Why does that matter? because FERPA gives parents the right to inspect educational records involving their children. That means schools potentially face two conflicting directives: state guidance discouraging disclosure, and federal standards increasingly favoring parental access. Then you add Congress stepping into the fight with legislation threatening federal funding consequences for districts that conceal transition-related information from parents. That's not a culture war anymore. That becomes a funding war, and school districts know it. Because if federal money gets tied to compliance, districts could eventually be forced to choose comply with Olympia or comply with Washington, D.C., which is honestly peak modern government dysfunction. Two levels of government issuing contradictory orders while local schools sit there like a guy trying to defuse a bomb with instructions written by divorced parents. Why this hits hard for families. Here's the reality most normal parents hear when they look at the issue. If my child is struggling emotionally, psychologically, socially, or medically, why would the school hide that from me? That's the emotional core of this entire debate. Now, supporters of the policy argue there are situations where disclosure could place a child at risk inside abusive homes. And yes, legitimate abuse situations absolutely exist. But critics argue the state is treating all parents as potential threats by default. That's a massive philosophical shift. Historically, American law has operated on the assumption that parents are the primary caretakers and decision makers unless proven unfit. The fear now among many families is that public institutions are slowly redefining that relationship, where schools become gatekeepers, bureaucracies become interpreters of safe parenting, and parental involvement becomes conditional. And once government power expands into family authority, history shows it rarely shrinks back voluntarily. The ballot fight is coming. The court battle isn't over. Appeals are expected, but the bigger battlefield may actually be the November ballot. Let's Go Washington successfully pushed a new initiative forward that would overturn HB 1296 and restore the stronger parental rights language from Initiative 2081. So voters are likely going to decide this directly. And regardless of where people land politically, this issue is not fading away because it taps into something primal. Who has the final say in raising children? Parents? Schools, state agencies, courts? That question is now sitting right in the center of Washington politics. One thing is very clear after this ruling. The parental rights fight in Washington is nowhere near finished. The courts are involved, federal agencies are involved, Congress is involved, state lawmakers are involved, and now voters are about to get involved too. This debate is going to shape education policy, constitutional law, and the relationship between families and government for years to come. And frankly, people better start paying attention now before decisions this massive get buried under slogans and sound bites. Because once authority transfers away from parents and towards institutions, getting it back is usually a whole lot harder. If you found this report valuable, make sure you follow and subscribe to Left Coast News and Behind the Line across YouTube, Spotify, Rumble, Brighteon, BitChute, X, Facebook, Instagram, TikTok, and Apple Podcasts. Drop your thoughts in the comments. Do parents have the right to know what's happening with their children at school? Or should schools have the authority to withhold certain information? Thanks for watching.